Hello, everyone. Welcome to the Disability Law Q&A with me, Martin Willemse. I am a partner at the firm of Samfiru, Tumarkin, and the Western Canada practice leader with respect to disability claims and other insurance claims. Our firm has offices in BC, Alberta, and Ontario, and we field questions from all over Canada other than Quebec and the territories. So if you do have questions regarding any disability cases or critical illness or life insurance, by all means, please send them through to social media platforms and we will respond to them as best as we can. Again, ask us questions about disability insurance law now. One question that often comes up is, what is the difference between an appeal period and a limitation period? When a person makes a claim for disability benefits and the claim is denied, the insurance company will invariably send a letter hopefully detailing the reasons why the claim had been denied and advising the insured, in other words, the person who's making the claim, of an option to appeal and providing a timeline. Usually they may say you've got 30 days or 60 days, whatever period they've decided to give you to appeal that denial. In other words, that's where you submit further information to the entity that already denied your claim in the hopes of getting them to overturn their decision. In the same letter, there may be a paragraph speaking about something called a limitation period, where it may say, and some insurance companies are more detailed on this, which is commendable, others are not. The limitation period is the timeline within which you can pursue a legal claim against the insurance company. When your claim is denied, your right to pursue a legal claim crystallizes. In other words, the policy is a contract, and the policy has rights and obligations. At the end of the person making the claim, they have the obligation to prove that they are unable to perform the essential duties of their occupation. And by doing so, they must submit evidence to support their position. That usually takes the form of letters or forms from a doctor and sometimes other collateral evidence. At the end of the insurance company, they have a duty to approve the claim and to pay benefits on receipt of satisfactory proof that the person is totally disabled within the meaning of the policy. If they deny the claim, they then have to advise that they are denying it. I've had people say to me that the insurance company just verbally told them that the claim was denied. If that is the case, phone them and insist that they put in writing why they have denied the claim. Once you have the denial in hand, then you will understand, hopefully, why the claim was denied. At that time, you will be in a position to say the insurance company has breached its obligations under the policy, which allows you to pursue a legal claim. In some instances, unionized employees cannot pursue legal claims against the insurance company, but it is very, very fact specific. It depends on the collective bargaining agreement, which will be reviewed if you do contact our firm. If you are in a position to pursue a legal claim, you can then make a choice. It's either you're going to pursue an appeal, which means that you're gathering further evidence from your treatment providers and submitting that to the insurance company who already denied your claim, asking them to reconsider their position. At the other end, as I said, there's the legal claim. You can pursue a legal claim by retaining a lawyer, which is what we do, and pursuing a legal claim for compensation under the policy. The benefits of pursuing a legal claim is that you don't have to deal with the insurance company any longer, and you have a lawyer advocating for you, advocating on your behalf, and advising you based on the evidence that is in place. But before we get retained, we also offer free consultations. In other words, we offer consultations to people to review their documents. If the claim has been denied, we can look at the denial letter itself. We can review the policy if you have it available, and we can look at other evidence, for example, the medical evidence, clinical records, consult reports that may be available to give you our advice, at least our opinion, as to what your options are. And then knowledge is power. Then you can make an informed decision as to how you want to deal with it and how you want to proceed with or how to navigate the denial of your claim. Remember, as I've said before, with an appeal, pursuing that option means you're going back to the same entity who denied your claim. As I've said before, as we started this out, what is the difference between an appeal period and limitation period? An appeal period is something which the insurance company may say to you, you've got this amount of time to pursue an appeal. I sometimes have an issue with that because the policy may not deal with appeals. They often don't. So if the insurance company just unilaterally mandates a certain appeal period, I don't think that is enforceable, because the policy also requires that the insurance company and the law, common law, requires that the insurance company adjudicates claims in good faith. So if there is a mandatory appeal period in your policy, that's something different. If there isn't, then I don't think their timelines apply, really. But the more important thing is, if you have a claim that has been denied and you are in a position to pursue a legal claim, there is a 2-year timeline, depending on which province you are in, within which you can pursue a legal claim. And that timeline runs regardless of whether you are pursuing an appeal. So generally, the limitation period is 2 years. It usually runs from the date of denial or the date that the last payment had been made or would have been made. It is crucial that you do not miss the limitation period if you do engage in the appeal process. Prior to 2012, the limitation period was 1 year, and I have been consulted by many people who had, in good faith, engaged in the appeal process, hoping that the insurance company would approve their claims, and had done so over and over again, to the point that the insurance company said, well, this is our final decision. We're not going to approve your claim. Then they consult a lawyer, only to find that the limitation period within which they could pursue a legal claim had expired, and unfortunately, there was nothing that they could do. So the message here is, if your claim is denied and you have questions, reach out to somebody at our firm. We've got, as I said, we've got offices through various provinces, and we can have one of our disability lawyers review your circumstances and advise you what your options are, and then you can make an informed decision. But again, crucially, do not miss the limitation period. And if you've got questions, once you've received the denial letter regarding that, by all means reach out to us and we can have a discussion with you. Again, we do this on a free consultation basis. We've got a question from Shauna. Can I retire and receive public sector pension LAPP, in brackets, not CPP, while on LTD payment? Shauna, I'd recommend that you actually contact us, phone one of our lawyers to have a discussion with you. I'm not quite sure what the public sector pension LLP is. I do know that federal government employees do receive, I think it's the PSSA pension. Quite often the insurance companies do require that if you are eligible for other sources of income, for example, benefits pursuant medical pension pursuant to the PSSA and CPP disability benefits, you have to apply for those. And if you don't, they can unilaterally just deduct them. But in this situation, I think you are eligible to apply, but what you would want to know is how would it impact your LTD benefits. So on that front, I think best avenue for you is to contact our firm and have a discussion with one of our lawyers so they can review the policy with you to see how it will impact you. Again, question on YouTube from Shauna, LTD clause. LTD payment will stop if I elect to receive early retirement benefits if earlier. Does it mean if I have not received 85 factor for full pension, not on reduced pension? It's a bit of a convoluted question. It really depends on the language of your policy. Some policies may provide that benefits terminate with certain triggering events. One of those events would be if you retire. Now, if you're forced to take early retirement with a reduced pension, the question then becomes, how does that impact your entitlement to benefits? Does it terminate? And secondly, does it impact the actual calculation of the benefit, which is what this question is referring to? There's something called an 85% all source maximum. What that means is, for the vast majority of policies, there are direct offsets and indirect offsets. Direct offsets mean that the insurance company can deduct dollar for dollar certain other sources of income, like CPP disability or WorkSafe benefits, and other indirect sources of income. For example, benefits that you may receive through some association, sometimes severance, sometimes children's benefits that you may receive under CPP. That is what this question is referring to by Shauna. It is the 85 all source max, which means that anything, if you add all the sources of income that you're receiving together, anything that exceeds 85% of your pre-disability income will also be deducted from your LTD benefit. I know it can sound complicated and it can be very overwhelming, especially if you're dealing with a disability claim, dealing with a disability, having to navigate the medical system, trying to get better, not having an income, having financial obligations, and trying to understand the language of your policy and how certain other factors, like other income, may impact your entitlement. Again, that is why we're here. We can review those with you. Not as easy to respond to questions without having all the evidence, or at least all the information. So if you've got further questions on this, I'm happy to review the policy, and our firm and the members of our team will be happy to review the policy with you, so we can get a better understanding of what the question is, what the policy provides for, so that we can give you our understanding of how that would impact you if you were to take early retirement. There's a question from AB1. Employee laid off 1 month of, sorry, give me 1 second. Employee laid off 1 month after returning from 26 weeks compassionate care leave, 11.5 years of service full-time. I'm assuming this refers to a severance question, which again, this is the disability law Q&A. We do offer employment law Q&A questions as well. And there's one tomorrow, Wednesday at 1 p.m. Eastern Standard Time. So please post your question then, and my partner Lior Samfiru will be able to respond to that question. There's a question on Facebook from Elmo. I'm currently on LTD, and because of my disability, I have to move to be closer to my family so that I can have extra support. It means that I will be moving to a different province and likely wouldn't be able to return to my job if and when I get better. Will I be cut off from my insurance for this? This is a very good question, because I think you're understanding the nuances here. It's not simply the fact that you are moving from one province to another, which may impact the disability benefit. It may be looked at differently. I get asked this question quite often. I have not seen a policy that prevents a person from moving from one province to another, which means that their benefits would be terminated simply because of the fact that they're moving. There are policies that do provide that if you leave the country for an extended period of time, beyond, say, 30 days or 90 days or whatever it would be, without the consent of the insurance company, that they can suspend or terminate benefits. But I haven't seen ones dealing with promises. But the bigger question is, how will the insurance company respond to this? You're receiving long-term disability benefits. You're now moving from one province to another, which means that you're moving away from your point of employment, your place of employment, and possibly also from your treating doctors. So will the insurance company look at that you're basically not interested in returning to your occupation or to your employer? They could, but it really depends on the circumstances. If you do have continuous employment, remember the policy always provides that you have to prove that you cannot perform the duties of your own occupation and then later on another occupation, which you can use against the insurer, because the occupation that they are looking at is not limited to your job with your employer. It is your occupation in the labor market for any employer. So if you did move, I strongly suggest that you make sure that you see your doctors regularly and that you try, even if it is remotely, but when you move to the new province, that you try and find someone in terms of treatment, a new doctor and other treatment providers who may allow you to continue, so that there's a continuum with respect to the treatment that you're receiving, because that's another thing that they would be looking at. Under the terms of the policy, you have to prove that you are under the regular care of a physician and that you are in an appropriate treatment program for your condition. And if there's a gap there's a lapse, then the insurance company may turn their eye on you, and be looking at your claim with more scrutiny. So it's not an easy thing to manage. I get that, but I also understand that when people are on LTD, when they're receiving LTD benefits, obviously it's only a percentage of their pre-disability income. They may struggle financially, and it may make sense to move closer to family or even in with family, so that you can get further support, not just financially, but emotionally and also with respect to treatment. So if you've got further questions on that, again, please reach out to our firm and we can review your circumstances with you in a better way. And as you can see on the screen, go to disabilityrights.ca. Okay. Then we have a question from Smashley. My aunt is currently on disability. She's going to be receiving some inheritance, but is worried about how this will affect her payments. What should she do, and what should she tell her insurer? This is a great question. Remember what I said earlier with respect to the policy provides that certain other sources of income may be deducted from your LTD benefit amount. So, if you do receive inheritance, because it's not the first time that this question has come up, I have never seen a policy that provides for inheritance money to be deducted from the person's LTD benefit. You are obligated. When you receive your approval letter, quite often the insurance company will say, if you are eligible for other sources of income, you should apply for those and immediately inform the insurance company when you receive those. Inheritance is not income. It's not income that you're receiving due to your labor. It's not something that you contributed to, like CPP disability, the CPP plan, or that you're contributing through your employment to the workers' compensation plan, where if you will receive benefits based on your inability to work, which would be loss of income benefits. Inheritance is not that. Inheritance is something that you're receiving. It's a certain sum of money, but it's not because of your labor that you're receiving it. So I will always say this because I'm a lawyer. So without committing 100% to anything, we would want to review the policy. But if the policy is silent on that fact, I do not see inheritance to be an offset. And if you do receive inheritance, I don't see that there's any reason to inform the insurance company of that. But again, we would want to look at the policy. I've seen situations where the insurance company has become aware of a person's inheritance, where, say, a person inherited $1 million and they're 60 years of age. The insurance company may take the position, well, with this money, this person isn't really motivated to return to work in any event, even if they were able to do so. So maybe their disability isn't really such that they cannot work. It's more so that they're looking at it as retirement because they've now got the financial funds to support themselves. I'm not sure what your age would be, but they may look at it in that sense. Not saying that they will, but consider that. Then there's a question on YouTube from Vasu. I am on LTD, coming up on 2 years soon. When applying for CPP disability for temporary illness after a motor vehicle accident, will my pension and health benefits be discontinued? Okay, so Vasu is receiving LTD benefits coming up to the 2-year mark, which means that at the 2-year mark, there's going to be a change of the definition for total disability. Then Vasu will have to prove that they cannot work in any other occupation based on their transferable skills. Also applying for CPP disability, which means then that if approved, the federal government through Service Canada is also accepting that Vasu cannot work in any gainful occupation and that their disability is both severe and prolonged. That's the literal definition for CPP disability. So this question really relates to the employment relationship, which means that if the employer decides to terminate the extended health and pension contributions, are they allowed to do that? And there again, I think that would be something to ask an employment lawyer to maybe review the contract, your employment contract. And if the employment contract is silent on that, I've seen many cases where employers have terminated extended health benefits after a certain period of time, or they would have said to the person making the claim, who is on LTD, that they have to start paying their own premiums. That really becomes an issue between the employer and the person making the disability claim versus between the employee, the person making the claim, and the insurance company. So unless in some policies, it may provide that while you are receiving long-term disability benefits, there is a waiver of premium, which is another benefit. And if that waiver of premium is coupled to your extended health, then in theory, that should continue. RMAC says if you are receiving a diagnosis, or if you receive a diagnosis that is considered terminal, are you still eligible for LTD? RMAC, I'm sorry to hear that. What I would say to you is your disability policy will provide that if due to an illness or an injury, you are unable to perform the essential duties of your occupation, your own occupation or your regular occupation, then you are entitled to long-term disability benefits. It is irrelevant what the condition is unless the policy has certain conditions, certain restrictions. I've seen some of them, not many, which would provide that certain conditions are not eligible for LTD, and those would be sometimes psychiatric conditions or chronic fatigue or Epstein-Barr or something like that. They are very, very limited from what I've seen. I've seen maybe 3 or 4 over the time that I've been practicing LTD. So for the most majority, there won't be any restrictions on the condition itself. So are you eligible for LTD? The question is the condition that you have limiting you from performing the essential duties of your occupation? In other words, this is a good question again. If you have a diagnosis, that's very helpful, but it doesn't determine whether you're eligible for LTD or not. The way to get long-term disability benefits approved is, and I'll use this as an example because I see this a lot. And I've used this as an example many times. If you have a physician who has given you a diagnosis of depression, for example, the doctor writes in the attending physician statement, my patient has depression, therefore they cannot work. The claim is going to be denied. Why is it denied? It's denied because the diagnosis is one factor, but the most important thing in a disability claim is the consideration of functional impairment. What are the restrictions and limitations that would prevent you from performing the duties of your own occupation and later on any other occupation? So what does that mean in our example? If you have a diagnosis of depression, many people with depression work. So why can you not work? So the doctor needs to detail what those restrictions and limitations are. I've used this many times as an example. If you are a bank teller and you have some form of mental health condition, for example, anxiety, depression, and panic disorder, you have to work with the public. You have to deal with difficult clients. You have to work in such a way that you service people quickly so that you can get to the next customer. You have to be focused. You cannot make mistakes. You cannot make mistakes with any job, really, but this is a good example because you're working with money. You have to service clients, as I said. You have to respond to their questions in a timely manner and be able to think on the spot. So if you have depression and a panic disorder and anxiety, you may have difficulty to focus, to concentrate, to manage deadlines, to comprehend new information, to respond in time to questions posed to you, to deal with public, to deal with difficult people, where you may have an anxiety attack, which may manifest itself in a physical manner, where you may have sweat, where you have pounding heart rate. All of those things will be considered in terms of your disability to establish as to, are you disabled from performing your duties as a bank teller? If the doctor puts it in that context, and you explain as well, these are my duties in my occupation, and these are all my restrictions and limitations. The diagnosis is important, but understanding what the restrictions and limitations are as a result of that diagnosis is key. So again, going back to that question, you received a diagnosis that may be considered terminal. Detail the restrictions and limitations, or have your doctor detail the restrictions and limitations as to why that diagnosis is impacting your ability to perform the duties of your occupation, and then submit your claim to the insurance company. And if denied, RMAC, please reach out to our firm. Don't sit on it. Don't simply engage in the appeal process. Get in touch with our firm, speak to one of our lawyers, and we can review the denial letter with you, discuss with you what your circumstances are, and advise you of your options so that you can make an informed decision as to how to navigate that denial. I'm hoping that was helpful. Then, excuse me, you can go to, as again on the screen, you can go to disabilityrights.ca for more information. Then there's a question on Facebook from Pat. Pat says, my diabetes condition has become worse and I need time off to deal with it. Would this be covered by LTD? Again, similar to the previous question, having that diagnosis is important. We know that there are thousands, hundreds of thousands of people, probably, who live with diabetes, but who are also capable of working. So when you say that your condition has worsened and you need time off to deal with it, it really depends on what that means. If you intend to apply for LTD benefits based on a diagnosis of diabetes, you would want your doctor, maybe your endocrinologist as well, your family physician, to explain why it is that you cannot work in your own occupation, what your restrictions and limitations are, what your treatment is, and also make sure that you see your doctor on a very regular basis so that your doctor is in an informed position to provide an opinion and to support you with respect to going off of work. If you're seeing specialists, have them also opine on this if possible, and have your doctor understand what it is that is required, not simply giving a diagnosis of diabetes, but explaining what the restrictions and limitations are and how these impact your ability to perform your duties. So when you do go to see your doctor, also explain to your doctor what your occupational duties are. So if you have diabetes, you may have neuropathy, you may have chronic pain, you maybe have some other issue as well, many other issues. Have the doctor explain why it is that all those impact your ability to perform the duties of your occupation. So yes, the diagnosis is important, but more important would be the functional impairment. So with diabetes, yes, you can apply if your doctor supports you and have your doctor detail why that is. Ormax says, thank you. The treatment will certainly make it difficult, if not impossible, to work. I'm just confused about critical illness versus LTD and if there's an overlap or a threshold to transition. But that's a very good question. These are two different coverages. You can apply for both. If you do qualify for critical illness, assuming that it is, like you said, a very serious condition, it may be included in your critical illness policy. If it is, then submit that claim, because there are specific timelines within which you have to submit a critical illness claim, like LTD, but the critical illness one, get it in. Does that mean that you cannot apply for LTD? No, it does not. You can apply for both. The overlap may just simply be the evidence, but these are two different insurance products. If you have coverage for both, then you should be entitled to both 100%. They're not deducted from each other. Critical illness is one sum of money that gets paid to you if you do have a very serious diagnosis like it sounds you have. And the purpose of that is to allow you to access better treatment. Further, like you said, the treatment will certainly make it difficult, if not impossible, to work. I fully understand that. What that means is that you will have significant difficulties in performing, and I'm saying this not just to you, like you already know this, but to anybody listening. If it is treatment, for example, where you will receive serious chemotherapy, which will impact your ability to focus and concentrate, may lead to fatigue, may lead to pain, may lead to nausea, difficulty to concentrate. With a serious condition, there may also be a mental health disorder that accompanies it. All of that needs to be considered if you apply for LTD benefits. In your situation, not knowing all the facts, but reading between the lines, I think it's something that should be approved. And if it is not, again, please reach out to us. And if you've got further questions regarding this, I'm happy to have a discussion with you, or at least reach out to our firm and we will have one of our disability lawyers speak with you. I know this is a very difficult period for you that you're experiencing, but this is a claim that I would expect to be approved. You just have to make sure that you submit it in the correct manner and provide the correct information, but do not miss the timelines. With all of that being said, we've reached the end of this session. Thank you for tuning in. Continue to visit our website, go to disabilityrights.ca if you've got more questions. Our next Q&A will be an employment law Q&A. That is tomorrow, which is Wednesday, May the 22nd at 1 p.m. Eastern Standard Time with Samfiru, my partner in employment law. Thank you, everyone, and have a good day.